Hi everyone, thanks for coming. Hopefully you can see me and the slideshow that I've got on this Japanese knotweed presentation. We've had 4 questions already in advance, which are very interesting questions. If you do have any other questions as we go, try to raise them in the questions and answer section. I probably won't be able to get to them as we go through, but I'll try and take a look at those at the end if we've got time. So just to give a brief introduction about what this talk is going to cover, it's going to be a general summary of knotweed and the common issues in claims. So usually it's going to be claims between purchasers of properties against vendors in misrepresentation. It's going to be claims by purchasers against surveyors and possibly solicitors for professional negligence. And finally, it's going to be claims by property owners against their neighbours in nuisance. Then we're going to talk about some recent Court of Appeal case law, which is Davies and Bridgend. As I said, that's the Court of Appeal, but it's gone to the Supreme Court, I believe, and will be heard shortly on an interesting point about causation and diminution in value of properties, which also could affect limitation in whether you decide to bring certain claims that might go back over 6 years in history. And finally, we've had, as I say, 4 very interesting questions which raise strategy, limitation, damages and costs, and I'll address those at the end. But as I say, do feel free to raise any other questions. Right. So a quick summary. It's an invasive species originally brought to Kew Gardens, I think, from Japan in the 19th century by some Victorian botanists who thought it looked nice. It spreads along railways and watercourses, but surprisingly doesn't seem to spread if left undisturbed and surrounded by other vegetation, which seems to hem it in. Apart from railways and watercourses, it also, the other main way it spreads is by moving earth, so construction work, landscaping, or careless waste removal. The issue is often with purchases because it can lie dormant underground for years, up to 10 feet under, and then it can be reactivated years later. So vendors might be aware that this plant is present on their land. They'll probably know that it will knock off about 5% of the value of their land and cause them all sorts of headaches. So they might try to hide it or not declare it when transferring the property or when engaging in sale of the property. The usual rule on property transfers, as you'll know, is buyer beware. So it's up to the purchaser to examine the property and then they're stuck with anything they miss. But these days, most residential property transactions involve completion of a TA6 property transfer form, which I'm sure you'll all have seen. It's got the well-known question at question 7.8, which is a specific question on Japanese knotweed because it causes so much problems in property transactions. And it's got 3 answers: yes, no, or not known in respect of whether the property is affected by knotweed. There's a very long introduction section warning people completing the form that they need to be very careful about only giving answers that are within their knowledge, and if they don't know the answer, then they have to ask someone. But it also confusingly warns those relying on it that they have to make their own investigations and so on. So it goes both ways in litigation between purchasers and vendors. It's extremely important and well, in property transaction cases, because obviously civil judges don't like making findings of fraud, as anyone who's ever done a fraud trial will know. So that takes us on to the Misrepresentation Act, which effectively gives damages for fraud in circumstances where there has been a misrepresentation of fact, causing someone to enter into a contract, and where it subsequently it turns out that misrepresentation has been untrue, unless the person who made the misrepresentation can positively prove that they had reasonable ground to believe, and did believe up until the time the contract was made, that the facts represented were true. So there's 2 points to make about this section, and again, it's always worth reading because people know it's section 2.1 of the Act, but it's kind of a useful checklist. So the first point I'm going to make is about the key date being the entering into the contract or exchange. it doesn't matter how long before that the TA6 was completed, and it doesn't even matter whether the TA6 was signed or dated. That counts as a misrepresentation. If it says there's no knotweed, that's a representation, and if there is knotweed, then it's a misrepresentation. And of course, the other point is that it's up until the point at which the contract is entered. So if a vendor reasonably believes that a property is free from knotweed, and then before exchange of the contract discovers that's not true, they have a duty to put the record right with the purchaser. Otherwise, they're guilty of misrepresentation. The second point to make about this section is that it shifts the burdens of proof from the claimant to the defendant, which really matters in these cases, because ordinarily defendants to allegations of fraud can simply hold their hand up and say, well, I didn't know anything about this. I didn't try to deceive anyone. And it can obviously be a very arduous and difficult task to prove the state of someone's knowledge and when they had that knowledge. Of course, this reverses it so that the defendant will have to prove that they actually did hold this belief at the time of making the statement. And secondly, they'll have to prove that they had reasonable grounds for making that statement or for holding that belief. So that will either be, I inspected the garden, I knew what knotweed looked like, it wasn't anywhere to be seen, here's some evidence to support that account, or I instructed a surveyor or a gardener and they inspected the property and they told me there was no knotweed there. So that kind of thing. So it's a much more difficult thing for defendants to do, especially where you have knotweed expert evidence to say this is a 5-year-old plant. It would have been 10 feet tall and X meters wide. So it's a really significant point. Fraudulent misrepresentation, that's as opposed to negligent misrepresentation. It's worth just reminding ourselves of the definition of fraud set out in Derry and Peake. So a representation is fraudulent where it's false and it's been made, 1, knowingly, or 2, without belief in its truth, or 3, recklessly careless as to whether or not it's true or false. So in the context of knotweed, that would be a vendor not knowing what knotweed looks like and saying that there was none in the property, because of course, if you don't know what you're saying when you answer that question and you still make the misrepresentation, then you can't have had any belief in its truth, or alternatively, it was reckless to make that statement. Moving on then to case strategy. So as I said at the outset, there's 4 potential common situations where you have knotweed in litigation. First of all, we've got a purchaser suing a vendor for misrepresentation. Secondly, where a purchaser is suing a surveyor, or third, alternatively, a solicitor for professional negligence. Or finally, there's a nuisance claim where a landowner is suing a neighbour for either encroachment or threatened encroachment. I'm sorry to say that vendors are generally regarded as easy targets because they make mistakes quite frequently. They, at least out of the first 3 possible situations, they will often send letters of response before getting solicitors involved, which will say things like, well, I wasn't lying about this, or I wasn't guilty of misrepresentation because I didn't know what knotweed was, or I'd never heard of it in my life. So how can that be dishonest? Or they'll say things without first reviewing the documents that they have, and they'll say things that are inconsistent with their documentary evidence. So that is a reason why purchasers often go after vendors. It's not the usual situation as well where you're worried about them being good for the money, because often the vendor will have bought another property, so you'll know they've got an asset. And anyone who's bought property within the last 10 years, or at least 10 years ago, would probably have made quite a bit of money, because that's the way the property market has gone. So you could enforce judgment for costs and liability against their next property. Secondly, in terms of handling the claim, they won't have the benefit that professional indemnity insurers will have of having a go-to panel of specialist lawyers, knotweed experts, and valuation experts. So, for example, I've seen defendants instruct as their surveying expert a quantity surveyor rather than a valuation surveyor, and they were completely hopeless in terms of their experience of valuing properties. I've seen defendants instruct waste management experts rather than plant specialists as their knotweed experts. So those kind of mistakes might seem obvious, but they're very easily missed by a defendant who doesn't see it, who hasn't ever seen a knotweed trial, and won't, there's just a higher risk of them making a mistake, which is obviously an advantage to claimants looking to recover their loss. The next option, surveyor. I think every surveyor in practice must have faced a knotweed claim, or at least be very aware of them, because they often have, well, nowadays they have very carefully drafted contracts which seek to protect themselves from liability in the event that they miss a knotweed infestation. They seek to do that in two ways. First, by general limitations on the extent of liability owed to a particular person's. So, for example, mortgagee, the mortgage lender rather than the purchaser. And secondly, by limiting the scope. It's slightly different with RICS surveyors, because they, if they hold themselves out as an RICS surveyor with RICS branding, that's quite a high standard, and they're going to have to, the RICS expressly in their guidance expect surveyors to address knotweed where it is present and where it will affect valuation of a property. And of course, it will always affect valuation of a property. So looking at slightly more detail at the first of these approaches that surveyors use to defend themselves from claims is the famous case of Smith and Eric Bush. Lord Templeman said, "The valuer knows that 90% of purchasers in fact rely on a mortgage valuation and do not commission their own survey. There's great pressure on a purchaser to rely on the mortgage valuation. Many purchasers cannot afford a second valuation. If a purchaser obtains a second valuation, the sale may go off and both valuation fees will have been wasted. Moreover, he knows that mortgagees, such as building societies and the council, are trustworthy and that they appoint careful and competent valuers, and he trusts the professional man so appointed." And then the valuer also knows of the consequences of the potential consequences of them making a mistake, the disastrous consequences for purchasers. There is some mixed sort of guidance from the courts, because in a case, Smith and Eric Bush was a case with a relatively modest property where, as you can tell from that extract of the judgment, the purchaser couldn't afford a second mortgage valuation. If you're dealing with someone purchasing a multi-million-pound property and who is not willing to spend a couple of £100 getting their own, maybe not a couple of hundred, but several £100 getting their own survey, the courts will be less sympathetic of that. So in McCullough and Lane Fox, 96 case, so after Smith and Eric Bush, the Court of Appeal considered an attempt by a claimant to avoid a written disclaimer issued by the estate agents. The defendants, both orally and in their particulars, described a property to prospective purchasers as having grounds of nearly 1 acre. And the claimant told them he was going to demolish the property and rebuild on the site and would not be obtaining his own survey. And the claimant then exchanged contracts to buy the property for almost 900 grand, after which he discovered that the true area of the grounds was much less. And he sued, claiming that he'd overpaid for the property. And the Court of Appeal rejected the claimant's attempt to strike down the disclaimer by reference to Act 97. Lord Justice Hobhouse noted that the claimant had put himself forward as a sophisticated and experienced member of the public and had ample opportunity to read the particulars and was aware that it would contain a disclaimer. So again, it's about really the sophistication and the resources of the purchaser. So it's very fact specific. And the second way that surveyors have started to limit the scope of liability, and I think this is a more recent development, is by essentially describing the service that they're providing as being limited to examining the house alone and not the garden and not anything that could contain knotweed, or that kind of limitation in the scope. So they're not, the Consumer Rights Act obviously controls exclusion clauses very strictly. They need to be well signposted and easily accessible. So as I say, it's important to distinguish exclusion clauses, which are strictly regulated, from contracts of limited scope. it's likely unenforceable if it's an exclusion clause, because it's very difficult to separate the issue of valuation of a property from the question of whether or not it's infested with Japanese knotweed. But that's distinct from a case where a surveyor says, I have no idea about knotweed. I'm not qualified to comment on knotweed, so I can't provide that service. All I can do is provide services on the architectural and structural integrity of the property, and you'll need to get an environmental expert to conduct a survey of any environmental issues. So it's a subtle distinction, but it can be effective. You would need to consider, particularly in cases where it's an RICS registered surveyor, whether that is open to them, and also whether you can put pressure on, whether a claimant can put pressure on a surveyor through recourse to the RICS on the basis that effectively this surveyor is purporting to carry out RICS quality surveys that aren't up to their standards. The third potential situation is where a purchaser sues a solicitor. Solicitors obviously have a duty to warn clients of obvious risks. So where there is either a missing TA6 or an adverse answer on a TA6, even if it's just not known, the solicitor could arguably have a duty to recommend a knotweed survey. And lastly, having just discussed those sophisticated surveyor contracts, which limit the scope of the services provided, if a solicitor has conduct of organizing the survey, there could be an argument that the solicitor shouldn't be agreeing terms that exclude knotweed when it could have such a fundamental impact on the value of the property, and could conceivably knock off tens of thousands for the sake of what would be a minimal increase in the price of the survey, or simply just getting a different survey from an RS valuer that would address knotweed. The fourth situation is landowner suing their neighbour on the basis of nuisance. And I've included the quote from Sir Terence Etherton in Network Rail and Williams. A private nuisance is a violation of real property rights. That means it involves either an interference with the legal rights of an owner of land, such as the right to use and enjoy it, which is an inherent facet of a right of exclusive possession. And he goes on to say nuisance may be caused by inaction or omission, as well as by some positive activity. An occupier will be liable for continuing a nuisance caused by another person with knowledge or presumed knowledge if he or she fails to take reasonable means to bring it to an end when they had ample time to do so. So effectively, what he's talking about there is this category of nuisance, which is natural nuisance. And it's a duty to take reasonable steps. So it's not a strict liability situation. Hi everyone, sorry about that. It just lost connection for some reason. I will try and get the share the slides again. All right, so hopefully that is the slides visible again for everyone. Okay, so I think what I was talking about was this neighbor nuisance claim. I'm not sure where I lost you, but effectively a claim in natural nuisance for knotweed against the neighbor is going to be effectively a claim in negligence, that they should have done something about it, that a reasonable landowner would have done something about it. And then I was going to move on to case strategy in terms of pleading fraud. Again, this is going back to the misrepresentation claim. I think claimants and parties generally can be very wary of pleading fraud. I'm not sure that it necessarily adds a great deal to the costs of a knotweed claim. So it's not something I think you need to be overly careful of, or at least as careful of as you would need to be in some other situations where it might increase the cost of litigation. It's worthwhile in terms of enforcement if you think the defendant is someone who might try and hide their assets and might have significant pension assets, because of course if you've got a finding in fraud, you can enforce against their pension rights even if they are bankrupt. Section 2.1 of the Misrepresentation Act gives most of the advantages of a finding in fraud in terms of damages, but yeah, there is some recent case law that suggests defendants can defend a claim on the basis of a hypothetical contract that the claimant would have entered but for the misrepresentation. And I think there's another advantage in that for fraudulent misrepresentation, the test of foreseeability that applies to the tort of negligence does not apply in the context of the tort of deceit. So those are some reasons why it does make sense for a claimant to plead fraud in knotweed case, even if it doesn't at first sight add much to the claim in misrepresentation. Witness pitfalls. Again, obvious points, but it's worth just repeating because they're so obvious, so often missed. You need to address all of the aspects of the pleaded case. So for a claim in misrepresentation, the key date is the contract for sale, not exchange. You need to address inducement, reliance, and causation. So what effect did the misrepresentation have on them? What would they have done if the misrepresentation hadn't been made? Rather than what would they have done if they'd known the truth. And it's an obvious point as well, but beware identicate witness statements. Probably in the majority of cases I see involving spouses, most of their witness statements are verbatim the same for most of the witness statement. Now, that's not surprising really, because obviously they're giving the same evidence, really, they've experienced the same thing. And of course, there's a lot of pressure on solicitors to keep costs under control. But it's just helpful to remember that it's always, I think witnesses' best evidence is always in their own words, even if that might be somewhat imperfect and rough. It comes across as more authentic because it is more authentic. In terms of relief, treatment in residential domestic properties is usually by herbicide. That'll normally come in at about 5 to 10 grand, if not some slightly less. It gets much more expensive when the treatment suggested is excavation, and it can run easily into tens of thousands of pounds. But that might still be appropriate where the land in question is intended for development. Damages for distress and inconvenience, they're pretty negligible, hundreds of pounds, maybe 1,000 or two, would be quite a lot for that. And diminution in value, which is always or almost always the largest sum, it's usually in the region of 2 to 5% for a property. So even if you're talking about a property that's only worth, I mean, 500,000 pounds is still a lot of money, but it's not, it's close to the average property value. You're still talking about quite a lot of money easily in the potentially in the intermediate track if it's 5% of the property value. When added on to the treatment costs. And also for nuisance, you're looking for injunctive relief, possibly even before encroachment has taken place, if the neighbour is if the neighbour knows that there's knotweed on the land and if they're not doing anything about it. Okay. Other points to remember. I always think that Part 18s are useful in all litigation, but it's easy to overlook them when you're focused on every other aspect of the sequence of litigation. It's particularly useful in getting a party to nail the colours to the mast. So with claimants, they would want to ask what steps precisely the vendor took to inspect their garden before completing the TA6. Or with a neighbouring local authority landowner in a nuisance claim, they'd want to ask about knotweed policies, inspection records, and if the local authority doesn't have any, then that's something that could be an issue. For defendants, they'll want to ask about inducement, reliance, and causation. So where a vendor is being sued for misrepresentation, they'll want to ask whether the purchaser instructed a surveyor to look for knotweed. And if the surveyor didn't find anything, then they'll want to argue on a but-for causation basis that they haven't caused the loss complained of. For defendants' nuisance claims, they might want to ask about when the claimants first became aware of the knotweed, on the basis that it's difficult for a claimant to say that the defendant landowner has been careless in missing knotweed, where the claimant themselves have missed it, where the knotweed is restricted to a boundary between the properties. So again, that would be less of an issue where the claimant has brought it to the attention of the landowner and the landowner has refused or failed to act in reasonable time. And the same sort of issues can be explored by applications for specific disclosure. Some recent developments to address then. There's new RICS guidance effective from March 22. It doesn't really change anything. Nuisance or knotweed is still something that affects the value of your land. It's still something you have to control. Nobody has ever really thought that it is going to damage buildings significantly. So as I say, it doesn't really change anything. A more interesting recent development is the Court of Appeal's decision in Davies and Bridgend County Borough Council. The first and the majority of the judgment, the first point is it just confirms or clarifies Network Rail and Williams that diminution in value resulting from knotweed encroachment is not pure economic loss. So if the tort of nuisance is complete, in other words, if there's more than de minimis encroachment, then economic loss is consequent on the encroachment, and therefore it's not pure economic loss, it results from a tort. The second more interesting point is on causation and diminution in value. And this takes me on to a question that someone has asked about limitation. So the question, I think, was, when does limitation start to run in a nuisance claim? The first answer to that question is 6 years from accrual of the cause of action. So in a knotweed claim, bearing in mind that we're talking about a natural nuisance, is this duty akin to negligence. So 6 years from the date at which the reasonable landowner would have acted to abate the nuisance or treat the knotweed, rather than the moment of encroachment. The next point to make is that there's a great deal of uncertainty at present as to limitation for a claim in encroachment, and for limitation of the diminution in value aspect of the claim. So you'll probably all be aware that knotweed is a continuing nuisance, and that's fine for treatment because you can argue that every day the knotweed is extending, more treatment needs to be carried out, or more excavation needs to be carried out. But I think it's conceptually more difficult in a case of diminution in value, because at first instance you might think that if diminution in value arises from the stigma of a property being affected by knotweed, then that should happen from the moment there's a single piece of knotweed on the property. From that point on, a vendor of a property can't tick that box on the TA6. I can't say it's not free from knotweed, and that is what immediately drops the value, pretty much regardless of the extent of the knotweed, or almost regardless of the extent of the knotweed, because whoever's buying it is going to have to engage in all of the hassle, all of the stress of it, and they're just going to ask for, shooting from the hip, a sort of 2 to 5% discount probably. But in Davies and Bridgend, the Court of Appeal took a different view. It was a point that was raised in the respondent's notice, and it was dealt with relatively briefly at the end of the judgment. But essentially, the court rejected this causation defence. So I think on the facts of the case, Knotweed had encroached probably in early 2000s. They should have noticed it, and the defendant landowner should have noticed it and done something about it from about 2013, and then the claim was issued in 2018. So obviously the landowner was saying, well, this diminution had plummeted in value. The property had plummeted in value from 2000 when the encroachment happened, and by the time we were guilty of breach, we didn't cause that diminution in value. As I say, the Court of Appeal disagreed and held that although there is an attractive simplicity about the respondent's point on causation, I believe it's wrong. After 5 years of breach of duty on the part of the respondent, failing to treat the knotweed on its own land adequately, the knotweed was still encroaching on the claimant's land, and by treatment of the knotweed, and any treatment by the appellant would have been futile unless and until the respondent complied with its duty as a good neighbour and dealt with its own knotweed. The harm to the quiet enjoyment and amenity persists, precisely because the nuisance is a continuing one. The harm then has been caused by the breach of duty. So I would understand that if the issue had been, as I say, treatment of the ongoing encroachment or additional costs resulting from continuing nuisance. But as I say, it's difficult to understand that on the basis of just the stigma blight. And I think it's interesting to see what the Supreme Court will make of that decision. I note that the Court of Appeal finished the point by saying the respondent makes a rhetorical point about what would have happened if the period of breach had only been 1 month. The short answer is that is not the case. And it said, no doubt, there would be no breach of duty if it had only been for 1 month. That doesn't fill me with confidence because the thought experiment that the council had suggested was one in which the respondent had been in breach of duty for a month, so a month after the reasonable landowner would have acted. So I'm not sure that the Court of Appeal has dealt with that point convincingly, but we'll see what happens in the Supreme Court. If I had to make an argument to the contrary, I mean, it's worth noting that defendants often argue against this blight diminishing in value basis by saying that after 10 years of property with an insurance-backed guarantee, if there's been no resurgence of the knotweed, there must come a point, whether 10, 20, 30, 100 years, at least conceivably, that property is no longer affected by knotweed if it's been treated and if it doesn't reappear after a certain period of time. So that argument, there have been other cases where with nuisance where the argument has worked, and it could work in a knotweed nuisance case. And if that argument is right, then I think the Court of Appeal's decision is sustainable on the basis that by virtue of the defendant continuing the nuisance and not treating it all the way up to 2018, had they treated it back in early 2000s, it would no longer have been significantly affecting the land in 2018. So I think that is an argument that could and might be raised at the Supreme Court. But as I say, it's one that could go either way, and it's quite an interesting one. I would probably suggest actually that if people are worried about limitation, it's worth considering whether they should issue and then stay a claim, or agree a standstill agreement with defendants, and that will save both parties costs, obviously. That might not be that might not need to be incurred if the Supreme Court decision goes a particular way. I think I've had some other questions. So what do you think is the most optimum strategy step by step of defending claims of this nature? I suppose the first thing I'd say is nobody's going to be, no claimant solicitor dealing with this work is going to be intimidated by an over-the-top letter just saying that their case is generally rubbish. You need to go through each issue with your client. So in a vendor case, go back to the Misrepresentation Act and say, why did they think there was no knotweed? Check for any points on causation. Often with a conveyance, there'll be extensive correspondence, which might support or undermine a claim that a purchaser would have acted differently had the representation not been made. In a surveyor case, the starting point will be the instructions in the contract. Again, you'll need to consider the RICS obligations on your surveyor client if they are a member. I would also say get early involvement of a Japanese knotweed expert before drafting a defence, because you will want inspection of the property as soon as possible, because obviously after several years being allowed to pass, you won't be able to make any comment on the likely contemporary state of the property when the survey was carried out, and that can put a defendant at a disadvantage. You probably won't need a valuation expert too early on, because usually rule of thumb, a diminution in value is somewhere between 2 and 5%. So it's not as important to have early involvement from a valuation expert. It's something that my colleagues have addressed in a talk on the new fast and intermediate track rules in terms of costs, but it's worth remembering that costs, even under the intermediate track, are much more constrained. So it almost incentivizes parties to issue statements of case, issue and plead statements of case, and then stay a claim for a month, which the court will apparently now almost always impose for settlement. So you should use that, and I suppose I hesitate to say it, but I think it does justify claimants in being a little bit more trigger happy with issuing, because of course the consequences aren't so drastic, and because it can force defendants to nail their colours to the mast with a statement of truth. And obviously there's professional obligations on a lawyer in terms of what they can plead, and they need to have cogent evidence before they can plead certain facts. In terms of length of trial, it just depends on witnesses and expert evidence. It usually takes a few hours per party in cross-examination. Experts usually take about the same for each expert, but every case will be different. The average trial probably lasts for 2 to 3 days. Part 36 rule offers should always be made, in my view. Usually you'll have a pretty good idea of quantum, and if a claimant wins, they'll beat that offer, and likewise defendants should be able to have a good idea of what the quantum is likely to be. So make sure you use Part 36 offers, given the new consequences under the soon to be introduced cost reforms or CPR reforms. Also, remember the new rules on unreasonable conduct and the 50% cost sanction. The next question I've got is, what factors would the court apply in deciding if a claimant can recover the cost of excavation versus herbicide, and is there any case law? It's very fact specific, but generally, I think I've mentioned this earlier, but it will be whether excavation is proportionate and reasonable. So in circumstances where the landowner is trying to redevelop land and build on the affected plot, it probably will be proportionate to spend tens of thousands of pounds on excavation, if that then allows you to build on the land and not have probably more than that sum knocked off the value of the new property built. The other point is that often your knotweed expert will advise on whether treatment or excavation is preferable. So you need to make sure that your expert has instructions on what the plans are for the land, but also you'll be kind of bound by their sort of advice on what is reasonable and proportionate, and in terms of controlling the knotweed. And the final question I've got before I turn to anything in the Q&A is, are there any cost implications to be aware of in bringing and defending Japanese knotweed claims? As I've touched on just there, fast track and intermediate costs will apply to most of these claims, not all, but the vast majority from the 1st of October. So there will be much greater certainty over costs. As I say, it probably makes more sense to pull the trigger on litigation because we've now got the 1 month stay for settlement, and that means that claimants can call a defendant's bluff on, in terms of what they've said in their letter of response, and issue proceedings, see what the defence says, and then either settle or withdraw with very limited risk and at least a certain risk of what the adverse costs will be. Obviously, you can't engage in unreasonable behaviour because there's a 50% cost penalty, but so long as your client has reasonable grounds for making the allegation or setting out the statement of case that they've got, that won't be regarded as unreasonable behaviour, I don't think, save in exceptional circumstances. In terms of the costs, if it's a fast track matter, it's going to be band 4 for complexity because it's a property dispute or it's a professional negligence matter. In the intermediate track, it's going to be either a band 3 or a band 4, depending on complexity. The other point to make is that if it's longer than 3 days, which could easily happen, you could easily have a 5-day Knotweed trial if you've got 2 experts on each side and you know, a husband and wife on each side, that kind of thing. I'd say that will almost certainly be 4 or longer, which would be in the multi-track. I think those are all the questions that I had in advance, but I've got another one at the top here from Melanie Misselbrook. I've recently obtained a TA6 in which the seller ticked the box no, but the expert evidence suggests Knotweed was present before the transaction. Interested to know whether we should be adding the seller to the proceedings. The claimant's subsequent owner is suing the council for the spread of Knotweed from the council land to their land. The council have been successfully treating since they became aware of the existence of Knotweed. Yeah, I would say, I mean, I can't say this with any reliability from reading a 1-paragraph question, but it sounds to me that the council will have certainly a very strong defence to that claim, whereas the seller has some questions to answer. I suppose it depends on the extent and visibility of the Knotweed. As I say, judges don't like holding ordinary homeowners liable for what can be life-changing sums of money and costs. But if you've got a Knotweed expert saying this was definitely present, or at least probably present, and it should have been visible, then it's hard to see how a vendor could successfully defend that claim. I think that's all the questions, unless anyone has any other questions. Oh, got 3 Q&A. Sorry, I missed that. Nicola Ovenden. Hi, Nicola. In terms of solicitor's liability, if the home buyer's survey flags Knotweed, is there a duty of the solicitors to flag it to the buyers? Well, I mean, I'd say there's probably no, I don't think there's probably any benefit in going after the solicitors, because if the I mean, the home buyers survey should address the impact on value of the Knotweed, and if the purchaser already has knowledge of the Knotweed and its impact on the value, well, then they've got that knowledge, and it's hard to say what difference a solicitor telling them the same thing a second time would bring. The next question, also from Nicola, is what is council's view on the new fixed cost rules applying to Knotweed? Okay, so I think that was half an hour ago or 15 minutes ago, so I've already answered that. Anonymous attendee, as a property lawyer, when acting on behalf of a purchaser, what can we do to ensure no claims arise in the future? I think you probably mean as a vendor. I would say just tick not known, and unless you know about it, in which case you can't tick not known because that's factually incorrect. But in most cases you won't know. Just tick not known, and then the ball is in the purchaser's court, and it's up to them to conduct their own survey. It's going to be very difficult, not impossible, but very difficult to succeed in a claim where you said caveat emptor. I don't know. I think, unfortunately, most of these cases arrive because people fill out forms without reading them. We're all guilty of it, but it's just the way consumers behave. And that's why they tick no when they in fact don't know. Isabella Shaw, can we please get the slides? Yes, you can get the slides. I think Emma from Chambers is going to send them around on Monday. An anonymous attendee, what effect does the 10-year insurance have on diminution? liability claim. Does this differ depending on whether the problem is treated chemically but dig and dump? I mean, that's an interesting question. Defendants usually argue it, but I mean, fundamentally, if you're a purchaser and you've got, if it's a good market, and say you're looking at a terraced house on a street, and say there are, 5 terraced houses, pretty much all the same, pretty much going for the same price. If one of them has knotweed, in every case, you're going to say, I don't care if there's an insurance policy in place, an insurance-backed guarantee in place. I just don't want to deal with the hassle of it, because I'll have to have them come around spraying it. I'll have to declare on the TA6 when I'm selling it, and someone won't want it. So I'll just pick a different property, unless they're going to give me, 5, 10, 15 grand, whatever is going to make it worth the purchase as while. So I don't think it has much difficulty, although defendants will argue that it makes a difference. One more, again from an anonymous contributor. When issuing against the defendant, should we issue against the landlord or tenant or both? That is an interesting question. I'd need to think about that. Actually, I've never been asked that, surprisingly. I think from where, I mean, it's basically anyone who has control of the land. So I suppose if it's a long-term tenancy, then you could argue that the tenant is responsible for the knotweed and should have taken steps. I suppose it might also depend on the terms of the lease. One more question. If the TA6 has been answered to say no or not known regarding the knotweed, can inquiries be raised during the conveyancing process, such as can it be requested for the vendor to investigate or act reasonably? I mean, yeah, you can agree whatever you want really with the vendor. If I was for a vendor, I would say, I mean, it depends how badly they want the sale, but generally, I would advise a vendor to say, just don't get involved, because, give them access to the property, let them conduct their own sort of inspections. You've got nothing to hide. But because it is so difficult to find knotweed, you just don't want to be engaged in a situation where you might make a misrepresentation and then have to discharge the burden of proving that you had reasonable grounds for making it. I think that's all the questions and answers dealt with. Thank you very much for those who've asked questions, and thank you to all of you for attending. This has been 50 minutes, wow, already. So obviously it's a bit of a whistle-stop tour. It's probably been a bit basic for some people. It's probably not been detailed enough for others. So if you do have any questions, including about particular cases that you're struggling with at the moment and just want a second pair of eyes, feel free to send me an email either directly at ckennedy@decachambers.com or through my clerks. And I'll be happy to take a look at that and have a quick phone call with you to discuss. Because I think despite all of the detail I've gone into here, every claim will turn on its facts. It's an obvious point to make, but it's one that you always have to have at the front of your mind before you get carried away with the TA6 and being perhaps interpreting the TA6 overly strictly, or the solicitors, the surveyor's contractual terms overly strictly. So I'll leave it there and let you go and enjoy a sandwich or whatever it is, get back to work. But thank you again for attending. I really appreciate it, and happy to answer any questions in more detail afterwards. And as I say, the slides will be sent around on Monday. Thank you.